talking to the senior advocate Mr. Fali Nariman, I would point out to his book God Save the Supreme Court, about which he has mentioned in the previous video. Now, in this book he has mentioned an incident that took place during the Golaknath hearing in the court, and where he says that in court no advocate, no judge had ever poked fun at Nani Palkhivala. And there is an exception, very interesting, when he talks about the famous Allahabad High Court lawyer, advocate, the long-time Advocate General of UP, Mr. Kanahiya Mishra. I would request him to recall for the benefit of viewers that passage.
Yes, correct. You see, K.L. Mishra from Allahabad was definitely an all-time great amongst the great lawyers of India. I have never known anyone, as I said, neither judge nor lawyer, ever poking fun at the great Nani Palkhiwala's argument, at least not in court. This was dared by a great lawyer from Uttar Pradesh, Kanahiya Mishra, who did it quite defiantly in Golaknath's case in the year 1967. I was appearing as a junior with Palkhivala in Golaknath and K.L. Mishra was appearing on the other side as Advocate General for his state of Uttar Pradesh. In his oral argument, and this is how it all started, Palkhivala advocated the theory of implied limitations. He said that Article 368 of the Constitution, the article which deals with amendments of the Constitution, gave unrestricted powers to Parliament in its constituent capacity to amend each and every article of the Constitution. But, and this is what Palkhivala argued, there are inherent limitations. And Palkhivala relied upon the relevant part of Article 368, Clause 2, which said, the bill to amend the Constitution shall be presented to the President, who shall give his assent to the bill, and thereupon, this is what the article says, thereupon the Constitution shall stand amended in accordance with the terms of the bill. This must mean, Palkhivala argued, that at the end of the procedure for amending a Constitution, the Constitution must remain standing.
Yes, in its original form. Yes.
That is, it must remain. Therefore, a wholesale amendment that would be contrary to its preamble and its title was unthinkable, and therefore implied limitations have to be read into Article 368. That was his argument.
Yes.
He emphasized the word shall stand amended in 368 Clause 2, not once but several times, in words as well as in gestures. And as was customary with Palkhivala at that time, when he was a vigorous advocate, one of the best in the country, when he was agitated, he used both his hands to emphasize his point.
Yes.
When Kanahiya got up to reply, he submitted in a soft voice that there were no implied limitations to the amending power. And he made his submissions in low key. Unlike Palkhivala, he was not agitated. And after he stated the point, he poked fun at Palkhivala's emphasis on the words
stand.
Shall stand amended. What should it have said, my lords? He said. What should it have said? In mock surprise, should the clause have said the Constitution shall sit amended? And then he went on, no, my lords. And this was
yes.
K.L. Mishra.
Yes.
Plain English cannot be subverted to suit any particular point of view. Kanahiya, and this is what you must also know, all of you, was a master of the English language. His language was impeccable. One could perhaps outsmart him occasionally on law, but never on language. Siddharth Shankar Ray, senior advocate,
Yes.
once the youngest Chief Minister of West Bengal, has written a moving reference to Kanhaiyalal Mishra, and you will find it in the 125th post-centenary Silver Jubilee volume of the Allahabad High Court.
Allahabad High Court.
He tells us, and this is something I didn't know till I read the piece, that Kanhaiyalal scored 150 marks out of 150 marks in his English essay paper in the Indian Civil Service Examination,
ICS.
ICS, in which he appeared and passed
Yes.
back in the year 1926.
Okay.
And yet he was not selected,
Yes.
and others below him were preferred and selected. This was so irregular that the matter was even raised in England's Parliament. But then in the year 1926, Kanhaiyalal had committed an unpardonable sin. And his sin was he had joined the nationalist movement.
Okay.
And there was a black mark by the British against his name.
Against it.
His obtaining 10% marks in his English paper had a sequel.
Yes.
That's another story.
Yes.
Because it was Sir Arthur Quiller Couch, the well-known professor and the writer and the master of the English language and editor of the Oxford Book of English Verse, who examined and marked Kanhaiyalal's paper back in the year 1926. He was so impressed that he not only gave him full marks, he put the trouble of writing a personal letter to Kanhaiyalal's professor in Allahabad University.
Okay.
And in it he summarized Miss K.L. Mishra's brilliance in one eloquent sentence. And this is the sentence. It was an Englishman who conquered India, but it is only Kanhaiyalal who conquered English.
Wonderful, sir.
Beautiful.
Very well said it is.
It was the Englishman who conquered India, but it was only Kanhaiyalal who conquered English. That Quiller Couch should have the enthusiasm to write to someone in India reminds me of another story.
Okay.
A true story, a tribute to the gracious days of old. The story is about Sir Dinshaw Mullah, one of the
Okay.
great jurists of
Yes.
our time. And the story was told to me personally, to me and my wife, by his granddaughter, who was a great friend of my late wife. Mullah had passed his bar examination
Yes.
and in college. And after returning to India, was wondering whether he should join the profession or pursue what he believed was his life's passion, which was to write poetry.
Okay.
Mullah fancied himself as some sort of a budding poet.
Yes.
In those days, the only form of communication was by letter that travelled by sea mail from India to England and England to
Yes.
India. Lord Tennyson was the poet laureate of England. He never knew Mullah, but he wrote a letter to Tennyson just the same. He sent the English poet some of his poems, earnestly inquiring whether he should take up his career in the law or whether he should stick to poetry. Lord Tennyson, seeing a letter from some forlorn student in faraway India, promptly picked up pen and paper. Just see the
Yes.
courtesy
Yes.
of those days. Pen and paper.
Paper.
Here nobody would, without pen and paper, they wouldn't even bother. He wrote back in his own long hand, "Dear Mr. Mullah, I thank you for your letter and your poems. I have read your poems and I think you should stick to the law." How beautiful.
Yes, to put it across.
Yeah.
Yes.
Just imagine if Tennyson had not written back to Mullah and Mullah had embarked on his urge to write poetry, abandoning the legal profession, the entire jurisprudence of modern India would have been
Would
different.
have been different. Quite
Because
right.
he was
sir.
one
Yes,
of our great
one-
jurists. He was the original
Mullahs,
jurist
yes.
of
Mullah
India.
and
There's
Mullah,
no
yes,
doubt
yes,
about it.
yes.
Sir Dinshaw Mullah. Mullah was a great lawyer and jurist, but unfortunately not a very good advocate.
Okay.
K.L. Mishra, however, was one of the most powerful advocates of his time and one of the most persuasive. It is recorded, and you must also hear this, that Chief Justice Earl Warren of the US Supreme Court, the most popular Chief Justice, the 14th Chief Justice of the United States from 1953 way up to 1969. He told Kanahiya after meeting and hearing him speak in Banaras, in Varanasi, that if they had counsel like him back in the United States, he as Chief Justice would waive the time limit to hear such argument.
Okay.
Remarkable.
Yes, sir.
So, from out of the mouth of Earl Warren.
Warren, this is something extraordinary.
As you know,
yes.
the maximum time limit for oral argument in the US Supreme Court is not exceeding 30 minutes. A great tribute to a great advocate by a great judge.
Yes, quite right.
Mishra also argued the Bliss case, etc. I had the privilege of listening to him when arguing Bhai Pratap's case in Bombay in the criminal appeal, when he was there for about a month in the 1960s. He treated the court with utmost courtesy, a treatment which was reciprocated by the bench. He did not succeed in the case, and the judges kept questioning him, questions which he coolly answered. He knew, like what all great advocates know, that you must never lose your temper at a judge. It's losing half the battle in court. If you have a temper and get upset at what the judge sometimes tells you, control your temper, and if you cannot control it, find some excuse to get angry with your junior sitting next to you, and the judge will think you are unnecessarily losing your temper, or a young man who is trying to assist you. Kanahiya knew the tricks of the trade, and the tricks of the trade is not a disparaging remark. Remember, it is a mark of appreciation for a person steeped in the fine art of advocacy, which after all is the art of gently persuading the judge to your point of view. Not persuading angrily or haughtily, but gently.
It's part of court craft. Yes.
It is an illusion that great cases are won or lost because of their inherent strength or weakness. In any case, it is not universally true, because advocacy plays a vital role simply because the judge is also human like the advocate. The only difference is he or she is trained to control their emotions better.
Thank you. We come to the end of this video, and in the next we would have an interesting case, perhaps an unparalleled incident where a judge of the Supreme Court called upon the Chief Justice of India to file an affidavit. Thank you.